Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Nate.
Good morning, Your Honor.
Let's see, I have Ms. Flowers.
Can you hear me?
Yeah, I can hear you now.
Okay, good morning.
Let's call your case to get you guys started. We are on the record calling 22179-054. This file is entitled LVNV Funding versus Bonita Flowers. This appears to be our second pretrial. Your appearances.
Preston Nate, P77884, appearing for LVNV funding.
And what is your name, ma'am?
Bonita Flowers.
Okay, this is our second pretrial. When we were last together on April 21st, the court opened your written discovery. Where are we on this file?
I'll give you an update, Ms. Flowers. Obviously, correct me if I missed anything, but it looks like she was able to contact our office just this last week or so. So it looks like we've got set up to get her some documents that she's requesting. I'm not sure if the court's amenable to setting this for one more pretrial, or if we do need to schedule a motion for summary date. I mean, hopefully it should be enough time to get her those documents, but it looks like we're going to be getting all the documents that we have over to you, Ms. Flowers, for review and that you requested. Does that sound about right, or?
Yes, I agree.
Okay, great, yeah.
All right, then I'm going to continue your written discovery. I'm going to give you a return date. And that will be June 16 at 10 o'clock. Does that work for everybody?
June 16th at 10 a.m. It'll still be Zoom, Your Honor?
Ma'am, we're going to be Zoom, I think, for the indefinite future.
I was just making sure.
I don't see us going away from Zoom.
Well, that's a good thing. I don't want to have to pay for parking for a few minutes in court.
Right, you know, that I think one of the things that the Supreme Court right now is in the process of trying to generate a rule, you know, concerning Zoom. And there are basically two schools of thought. One is do everything on Zoom. One is leave it discretionary with the judge. But I think certainly in matters of pretrials, I don't see why it's, you know, you would do anything other than Zoom. I think, you know, in a trial where you got to evaluate credibility, I don't know how you evaluate credibility on a television set. It needs to be on motions, which are done as a matter of law. In fact, on pretrials, those should be done routinely on Zoom. In any event, we will talk to you guys again June 16th at 10 o'clock on Zoom. Your written discovery remains open. Is there anything else we can accomplish today?
That sounds good to me. Thank you, Your Honor.
And we're going to send you guys out of order. Thank you both for coming in, and let's be safe.
You bet.
Have a good day.
Thank you. You too. That's your only file, Mr. Nate? Yep. Okay. June 16th, 10 o'clock. It's 5:19. Walker. I don't see the Walker. Rashard. Radney. Yeah. Rashard. Radney. 223 Walker. All right, good morning.
Morning, Your Honor.
We are on the record calling 22242-388. Geraldine Radney versus Henry Ford Health System. This is date and time for first pretrial on a matter which was originally commenced by the filing of a complaint in small claims and removed to the general civil docket. Your respective appearances.
Daniel Rasher, P70789, on behalf of defendant Henry Ford Health System.
All right, good morning.
Good morning. Good morning, Your Honor.
Good
We are
morning,
on the
sir.
record calling 22242-388. Geraldine Radney versus Henry Ford Health System. This is date and time for first pretrial on a matter which was originally commenced by the filing of a complaint in small claims and removed to the general civil docket. Your respective appearances.
Daniel Rasher, P70789, on behalf of defendant Henry Ford Health System.
All right, good morning.
Good morning. Good morning, Your Honor.
Good
We are
morning,
on the
sir.
record calling 22242-388. Is that Geraldine Radney versus Henry
What's
Ford Health
happening?
System. This is
Oh.
date.
Can you hear me, sir?
Yes.
May I speak? May I speak now?
Yes. What is your name, ma'am?
My name is Mrs. Geraldine Radney.
All right. You are the plaintiff in this matter.
Yes,
you
ma'am.
commenced the filing of a complaint in the small claims division, and the matter was removed to general civil. General civil is very different than small claims. In small claims, lawyers are not permitted. In small claims, the court is not required to follow the rules of evidence other than privilege. The court is not required to follow the case law, statutory law, but is to do, quote, substantial justice. All that is very different where we are now. In the general civil docket, the court is required to follow the Michigan court rules, follow the statutes, follow the case law. And if you elect to represent yourself, as is your constitutional right, the same rules that bind the lawyer in general civil will bind you. You will not be heard to say, I didn't know a rule. Do you understand that?
Yes, and I have a request.
Ma'am,
Yes, ma'am.
what is your,
Sir, my request is that I would like to dismiss the case without prejudice.
you want to dismiss the matter without prejudice?
Yes, sir.
Counsel, what's your position in that regard?
I have no objection, Your Honor.
All right, given the request of the plaintiff on the record to dismiss the matter without prejudice, the case will be dismissed without prejudice. I will send out to both of you an order. Thank you both for coming in, and let's be safe.
Thank you.
Judge.
Thanks for coming in. You're off the record.
Have a great day.
You too, sir.
Thank you.
Dismissal. Good morning, counsel.
Good morning, Your Honor. How are you?
Not bad. How about yourself?
I am good.
Who are you representing today?
I am representing Allstate Insurance Company on the Anthony McGee matter.
I have Mr. Fowler, and I think we can get started in just a second.
Fabulous. Thank you so much.
We are on the record. This is 2-1-161-887. Anthony McGee versus Allstate. date and time for pretrial, your respective appearances.
Joseph Falls on behalf of the plaintiff, Your Honor, P800521.
Good morning, Your Honor. Kristen LaFleur appearing on behalf of defendant Allstate Insurance Company P78742.
All right, since we were last together, you people have managed to kill quite a few trees. So as I understand it, you stipulated, we have 2 orders for stipulating for discovery, and then we have an upcoming IME. Are we having any problems with our discovery?
Not on my end, Your Honor.
Not at this point in time. Mr. Falzon and I have talked, and I think we're in agreement as to what we're doing going forward, and we should be able to hopefully resolve once the depositions are conducted.
Yeah, I hear that a lot. So when are our depositions set?
The plaintiff's deposition is May 31st. We're still working on getting a date, I think, right, Mr. Falzon, for my adjuster?
Okay. And we're comfortable that we're in my jurisdiction?
Yes, Your Honor.
Yes, Your Honor.
$25,000.
No, Your Honor.
All right, so you got the dep scheduled for May 31st. How about I give you guys a June 16th return date? By that point in time, if you have not accomplished both depositions, we will at least know, hopefully, when the next one is scheduled.
June-
Absolutely, Judge.
June 16th. Yes, Your Honor.
That's okay with everybody?
Yes, sir.
Okay?
That's
June
okay, Judge.
10 o'clock, we'll try this again. Ballpark, Mr. Falzon, how much are we arguing about these days?
According to my last billing review checklist, we're somewhere in the realm of 15.5.
Okay, you should be able to kill that because you only need 2 deps.
Yeah.
And we'll get it started. So we'll talk to you guys again, June 16th at 10 o'clock. Anything else we can do today?
No, Your Honor.
No, Your Honor.
Come in, let's be safe out there.
I'm also supposed to tell you I just got off the phone with Dave Kane, and I'm supposed to tell you hello.
Would you tell him I said hello?
I will. I got a facilitation going with him too, so
Oh, okay. And tell him to tell Peggy I said hello too.
I will. Thank you.
My former law partner,
Oh, very nice. Yes.
before my hair turned gray. You guys have a great day. Let's be safe.
You
You
too.
too. Thank you, Judge.
Coming
Have
in.
a good one, Joe.
You too.
Okay. Let's get them return on date. June 16th. Hello?
Hello,
Who is this?
this is Danian Woodson. Sorry.
Ms. Woodson, why are you here?
We have a trial scheduled today with Malika Williams. I'm sorry, Mildrika Williams.
I don't think so. What judge are you looking for?
We were told courtroom 539.
What is your case number? It should be in the upper right-hand corner of the pleading.
22-242-426.
22242-426?
Yes.
22242-426. 2224. you have a pretrial, not a trial.
Okay, sorry. We thought it was a trial. We
And-
did ask, yes, for a trial date.
And you are whom?
Danian Woodson, I represent Simro.
Okay, I don't see Williams as of yet.
Okay,
Let me see, Ms. Woodson, let me check one thing. I have one phone number, maybe this is her, let's find out.
Okay.
Kind of hard to tell when you get phone numbers. Hello,
Hello,
oh, what is your name?
Mildrika Williams.
Mildred, what?
Mildrika Williams.
I
Okay,
believe that's the
apparently
plan.
we have both sides.
Yes.
All right, let's call your case.
Okay,
This is file number 222422426. Meldrika Williams versus Simro Investments. This is a pretrial. Could I have your respective appearances?
I'm sorry,
Good
I didn't
morning.
hear the last.
I need your appearances. Tell me your name, ma'am.
My name is Mildrika Williams.
All right, Ms. Woodson, what is your name and your bar number?
good morning, Your Honor. Danian Woodson, P 68870 on behalf of Simro.
All right, this case was filed initially, Ms. Williams. You commenced by the filing of a complaint in the Small Claims Division of the 36th District Court. The defendant removed it to the general civil docket. I want to make sure you understand that the environment now legal environment is entirely different than it was before. In small claims, which is where you were, the court is not required to follow the rules of evidence other than privilege. The court is not required to follow the case law and the statutory law, but is to do, quote, substantial justice. That is all behind us. We're in an entirely different set of rules. In the general civil docket, which is where we are now, the court is required to follow the Michigan rules of evidence, the Michigan court rules, as well as the statutory and case law. And attorneys are not permitted in the small claims division, but as you can see, the defendant is represented here by an attorney. You have a right likewise to have an attorney in the general civil division. Do you understand the differences?
Yes, I do.
Now, are you intending to represent yourself or do you intend to get counsel?
I can represent myself.
You have an absolute constitutional right to do that. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Ms. Woodson are going to bind you. Do you understand that?
Yes, I do.
Okay, where are we on this file, people?
Sorry,
Where are we on the file?
Your Honor, we're,
Conversation or you just ran. Now, I don't see, before I go any further, Ms. Woodson, I don't see your answer.
we didn't receive a complaint, Your Honor. Initially, it was just the small claims form, which was just the general allegations that had the hearing date. When the matter was removed, we did not receive a more formal complaint.
They don't have to file a new formal complaint. You have to file an answer.
Okay, well, we'll file a motion for summary disposition, Your Honor.
You should have their affidavit. That was in the file. And that serves as a complaint in small claims.
I'm sorry, I didn't receive a copy of the affidavit, just that the claim was based on the return of security deposit and damage to furniture. That was the only thing that was listed. There was no affidavit attached to the documents that we received.
Well, I'm looking forward to your answer, counsel, because your answer was due within 14 days of the day you filed the petition to remove, which apparently was done on April the 19th. So it should have been done by now.
And again, I'm sorry, Your Honor, we didn't receive an affidavit. We just saw the causes of action, and so we were prepared to come to defend.
Where did you see the causes of action? You obviously
It was
saw.
on the cover sheet. There was no affidavit attached. The cover sheet just said that the amount was $5,000 based on security deposit. And
You were served with the affidavit and the documents hit it affidavit and claim small claims, correct? That's what you were served with.
Yes, that's what my client was served with.
That is the complaint, counsel.
Oh, okay, then yeah, we will, I'm sorry, Your Honor, I was expecting a little bit more to respond to, but yeah, we can definitely respond to this.
All right,
I'll respond to this today.
what I'm going to do is I'm going to open your written discovery. And I'll give you guys a return date. Does June 16th at 10 o'clock work for both of you?
No, it doesn't,
Why not?
because my daughter graduated on June 16th
From where?
from 8th grade.
Good for you.
Thank you.
How about June 15th, the day before, or June 17th? 17th is a Friday. Does that work better for everybody?
I'm just checking with my clients really quickly.
June 17th. So we're open for me.
June 17th is fine, Your Honor.
That work for you, ma'am?
Yes, it works for me.
Okay, June 17th at 10 o'clock will be our next pretrial. Counsel,
Yes,
I need that answer.
okay,
Make sure I got your P number, your 68870.
yes.
Thank you. All right,
You're
we'll send it
welcome.
out today. And so June 17th will be our next, and 6/17, your written discovery is now open. Thank you both for coming in. We are
Okay.
correct.
Thank you.
Not in order to you both. Congratulations. But you
Thank
ain't
you.
done yet. Eighth
No, I'm
grade,
not.
ain't enough. Eighth grade ain't enough.
Have a good one, everyone. Stay
Right.
safe.
Let's be safe out there.
Okay.
All right, you too.
Mr. Perry, good morning.
Good morning, Judge.
I don't have your opponent as of yet, so let me get back to you in 5 minutes and we'll move forward then, okay?
All right, perfect.
Thank you. We are on the record calling file number 22179-389. The file is entitled Midland Credit Management versus Karen McAfee Walker. By a notice dated April 18th, 2022, this matter set for pretrial today, May 19th at 10 o'clock. It's now after 10:30. The defendant has failed to appear. Could I have your appearance, sir?
Good morning, Judge. Andrew Perry, P69402 on behalf of plaintiff.
All right, the plaintiff has appeared, defendant has failed to appear. By way of background, this file comes to us on a change of venue from the 17th District Court. Defendant having failed to appear, no good cause for that failure having been shown, the default of defendant McAfee Walker is hereby entered. We'll send it out to you today, sir.
All right, thanks, Judge. Have a great day.
Be safe. We're
You
off the record. Mr. Sobel, good morning.
Your Honor, good morning.
Who you
Hope-
representing today?
Your Honor, representing Gary Suggs, and LVMV funding versus Gary Suggs, case number.
Okay.
Yep.
I thought. Mr. Fay, so let's get started.
Okay.
This is 7-9. Mr. Fay,
Morning, Your Honor.
this is case number 21-168279, LVNV funding versus Gary Suggs. Your appearances, please.
It's Craig Fay, P81401 on behalf of plaintiff, LVNV funding.
Your Honor, Mark Sobel, P41764, covering for defendant Gary Suggs.
All right. My file indicates that we are scheduled for a motion for summary disposition today. Was an answer filed on behalf of the defendant?
So if I may, Your Honor, it looks like this matter just resolved. We did send a consent judgment over to opposing counsel's office yesterday. So we're just waiting for signature, and the matter, should be.
All those trees died for nothing.
Oh, they did. Yes, they did.
Yeah.
Okay, well, let's do this, guys. The case has been settled. You want to tell me the terms of settlement, please?
Sure. So the matter is going to be resolved by way of consent judgment. The settlement amount is $7,370. It's going to be paid over 28 payments of $250. Those payments will begin on May 31st, 2022. And then there will be one final payment in the amount of $370. And I believe that the exact date, the $370, the final payment is September 30th of 2024.
All right, Mr. Sobel, you agree to those terms?
Yes, Your Honor.
Okay, what I'm going to do then, gentlemen, is I'm going to dismiss your case without prejudice, and I will note that a consent judgment is to follow.
Sounds good, Your Honor.
Thank you, gentlemen.
Thank you. Have a good day.
Safe. Appreciate you coming in.
Take
We're
care.
off the record.
Bye.
Mr. Lakin,
Good morning.
how you doing?
Good. How you doing?
Pretty good, thank you.
Good.
Ms. Carson? Can you hear me? See, she doesn't seem to connected to audio yet. Ms. Carson?
Yes.
Oh, okay, we're ready to go then. We are on the record calling file number 22-180369. Lee Carson versus Bobby's Towing This is the date and time for pretrial. Could I have your appearance?
Mark Lakin for Bobby's Towing,
Bar number.
P41147.
And what is your name, ma'am?
Monique Carson.
All right. We opened your written discovery on this file back on April 21st. There has been an answer filed on behalf of the defendant. Where are we on this file, people? Everybody talking once.
Okay. The last thing you said, Judge, you cut out.
Oh, okay. I was pointing out that I opened written discovery on April 21st, and I was trying to see where we are on this file at this point. Has
Okay,
anybody, for example, done any written discovery?
Could I ask a question? When we answered, did we ask for a dismissal?
You filed an answer to affirmative defenses.
Yeah.
Then at the, in your prayer for relief, you asked the case to be dismissed.
Okay. We have not done any discovery. It's a very simple case. It's just a case of my client has a contract owns a towing company, has a contract with the City of Detroit Police Department, and she was asked to tow a vehicle. She has really no choice in that matter. And I would hope that the plaintiff would understand that. And we would actually be breaking the law to not follow the contract.
Ms. Carson?
That's not correct. There was no authorization to take my car. My car was parked. My keys was taken out of my pocket. My car was parked across the street. But I told him did not have any authorization to take the keys and haul my car away to an undisclosed location without any written Michigan registry, because the car is registered with the City of Michigan if it was abandoned or not. It was not abandoned, and my car was stolen from Bob's Towing. I had to go to a kiosk to pay a nominal fee. Also, they was refusing me to get the car, and then I had to come out of my own pocket with my own money for a car that was not in movement, and it was taken. They hauled it away. It was not authorized by no police department. There was no crime.
Stop you right there. How is it that you say it was not authorized by a police department?
Say it again.
Yeah, you said on 2 occasions that there was no authorization to tow the vehicle. I'm asking how you know that.
Because I was.
I'm sorry, ma'am. You cut off your microphone.
There was no.
I'm sorry, ma'am. Let's stop right here.
Yes.
As soon as you started to talk, your microphone was turned off. So I didn't hear a word you said other than because.
My car was not.
Let me start with my question again. How do you know there was no authorization from a police department to tow your vehicle?
There was not. There was
not.
not.
I understand that's your position. I'm asking you, how do you know that?
Because there was none. There was no reason to. My car was parked.
All right, we're done. Okay, I'm not getting anywhere here. All right, what I'm going to do then, you're not willing to be responsive. I'm not spending any more time arguing, trying to.
I'm asking you a question.
Ma'am, I'm going to, Mr. Lakin.
My comment is to this lady. I understand she has a beef, but I don't think the beef is with my client. It's with the Detroit Police Department. And we answered that way in the answer. Did she get the answer and read our answers?
Did you get their answer, ma'am?
Yes, I did.
All right.
And did you go to the precinct and check this out in any way, whether those answers were correct?
I didn't go to any police department to check for that was that somebody said that they were supposed to take my car. My car was not supposed to be taken at all. There's no reason for authorization to take my car.
All right, let's stop right here, ma'am. Do you understand how, at least from my perspective, you are saying 2 separate things? 1, you say there was no authorization. 2, you said there was no reason for authorization. So I'm obviously not a point to be able to do this here. Let us continue our written discovery, and I'll give you a return date The return date will be June 16th at 11 o'clock. That date and time work for everybody?
Yeah, that's fine.
Okay, written discovery continues. June 16th at 11 o'clock will be our next pretrial. Thank you both for coming in. We're off the record.
Thank you.
Mr. Kavanaugh? Mr. Green?
Good morning.
All right, let's call your case. This is file number 211711918. MS Oliver versus Stephen Edward Paulson and a Bearded Builder LLC. Your respective appearances.
Good morning, Your Honor. Alex Green IV, P82657 on behalf of plaintiff Wayshira MS Oliver.
Mr. Green?
Good morning, Judge Peter Kavanaugh, P53537 on behalf of the defendants, Stephen Edward Paulson II and a Bearded Builder LLC.
All right, gentlemen, where are we on this file? Last thing I see is I entered on May the 3rd, the order concerning plaintiff's motion to compel discovery and striking interrogatories. So where are we on this file?
So Judge, there was a second order that the court entered. The parties agreed to do a total of 2 depositions, one each for no more than 2 hours.
2 hours, right?
And there was an order entered by the court, and the parties have agreed on a date and time for both depositions.
And that's going to be when?
June 14th, beginning at 10 a.m.
Okay.
And we looked at some earlier dates, but those were the first, that's the first date that we
worked out for everybody.
Yes.
So we're going to proceed.
No
We
problem.
did agree to the depositions. There's an order to that effect. And so I anticipate, once discovery is completed, seeking summary disposition of the plaintiff's complaint. I don't know if the court wants to set a date by which that motion would be filed, or wait till it's filed and then schedule response and reply and hearing.
Well, I think the better way to proceed is I'm going to give you guys a return date with me on June 16th. By that time, we should have our pretrial, both depositions should be done. And both of you will have heard those depositions. And if you've not been able to resolve the file, then you'll have some idea from your when your transcripts will be available. And I'll give you a date to file your motion for summary disposition. Mr. Green, under the court rules, will have 3 weeks from the time the motion is filed before I can schedule a hearing. So let's just get ourselves positioned. Let's get our depositions done. And we'll see you guys next June 16th at 11 o'clock. Does that work for everybody?
Yes, Judge.
Mr. Green?
Yes, Your Honor.
Okay.
Yes.
So let's get these depositions done. And maybe, again, I don't know, because I'm obviously not going to be there for the depositions. Maybe something that you hear during the depositions will break the log jam. If not, get some idea from your respective court reporters how long it's going to be before the transcript is available. So when we talk again on June 16th, if we're not able to resolve the file, we'll have some idea how much time Mr. Kavanaugh will need before he can get his transcripts, and then obviously he's going to need some time after that to prepare his motion for summary disposition. Mr. Green, are you anticipating any dispositive motions?
I'm not, Your Honor, at this time.
Okay, so we'll talk to you guys again, June 16th at 11 o'clock. Let's get our depositions done and we'll talk to you then. Anything else, Joe?
No, Judge, thank
No,
you.
that's all, Your Honor. Thank
All right,
you.
appreciate you coming in. You're off the record. Let's be safe out there.
You too.
Thank you.
Thank you.